The Court of Appeal is expected to hear submissions today related to the Jean Rony Jean-Charles case, an immigration matter that has attracted widespread public debate since a recent Supreme Court ruling cleared the way for his return to the Bahamas from Haiti. In January, Supreme Court Justice Gregory Hilton found that Bahamas-born Jean-Charles, who had been detained by immigration officers last September and was sent to Haiti last November, was unlawfully detained and deported. In his ruling, the judge granted an order directing the Minister of Immigration and the Director of Immigration, forthwith but no later than 60 days after the return of Jean-Charles to the Bahamas and upon application made by Jean-Charles, to issue such status to him as would permit him to remain in the Bahamas and to legally seek gainful employment. The schedule of the Court of Appeal lists May 30th as the date of the substantive hearing. In the Notice of Motion to Appeal, dated February 2, 2018, the government submitted that the Supreme Court judge erred in law and principle in rejecting the contention of the appellants that the respondent had alternative means of redress available to him, and should have exhausted such redress before seeking to make a constitutional claim. In the circumstances, the learned judge was wrong to consider and determine the application for constitutional redress without affording the appellants a proper opportunity to respond, and his actions deprived the appellants of a fair hearing, court documents read. Further, the judge erred in relying on third-party evidence to support a constitutional claim when the said affidavit was specifically sworn solely for the purposes of the habeas corpus proceedings. In any event, having dismissed the respondent's habeas corpus claim, the affidavit in support of that claim sworn by the respondent's sister on his behalf fell away, and the judge made a grave error of law in determining the constitutional application in the absence of any affidavit evidence, or any admissible evidence, in support of the claim. The government also said the judge erred and misdirected himself in law in finding that the Jean-Charles's constitutional rights had been breached under Article 19 and/or 25, or at all. The government argued that there has been no evidence of the same. Additionally, it was submitted that the judge failed to give a proper interpretation of the powers and limitations of the Immigration Act with respect to the matter, and the judge was wrong in law and legal principle, and overreached his constitutional authority in ordering the appellants to issue travel documents to the respondent, and to issue such status to the respondent as would allow him to remain in the Bahamas and seek employment. Further, the government said the judge erred in awarding compensation. Attorney General Carl Bethel, Minister of Immigration Brent Simonet, former Director of Immigration William Pratt, Officer in charge of the Carmichael Road Detention Center Peter Joseph, and Royal Bahamas Defense Force Commodore Tellis Bethel are named as the appellants. Jean-Charles is named as the respondent. He is being represented by Attorney Fred Smith, QC. Attorney Lauren Klein is expected to appear on behalf of the government. Since the January ruling, the government has ensured that legal migrants caught entering the country appear before a magistrate. The government has also proposed amendments to the act, and a new law will allow officials to deport illegal migrants without court proceedings, in some cases.